go. All right, good afternoon, everybody. Thank you so much for joining us today at the Georgetown Law Federal Society chapter for discussion on the increasingly relevant and contentious issue regarding the constitutionality of the special counsel. For just a bit of background, special counsel is an individual appointed by the U.S. Attorney General to investigate and potentially prosecute a case of suspected criminal activity which a conflict of interest exists for the executive branch, typically the president. Special counsels have, probably unfortunately, become commonplace in our federal justice system, especially in recent years with the special counsel, Robert Mueller, being appointed under the Trump administration to investigate President Trump himself, and under the current Biden administration to investigate President Biden, his son Hunter, and, again, President Trump. These investigations have, for obvious reasons, received a massive amount of media attention, but the constitutionality of such a practice has largely gone under the radar. Notwithstanding law review articles and a 2018 Trump tweet claiming the appointment of the special counsel is totally, in all caps, unconstitutional, referring to the appointment of Robert Mueller at the time, this contention did not come into judicial fruition until this past July, when Judge Aileen Cannon of the Southern District of Florida dismissed Special Counsel Jack Smith's current investigation of President Trump handling of classified documents, finding that the appointment of Jack Smith raised serious constitutional issues under Article 2, especially without statutory provision by Congress. So, to help us get into the specifics of this complicated issue and the merits of such a claim, we have two highly accomplished and incredibly knowledgeable speakers with us today, Professor Josh Blackman and Mr. Stuart M. Gerson.
I'm not so accomplished. I just speak high. It's
loud, not
you're
here, so that's enough.
Yeah, I hope to be incredible, not incredible, but incredible.
Incredible, absolutely. So just to prove my point that we have two highly accomplished speakers here, Professor Blackman is a professor at South Texas College of Law, Houston, where he holds a centennial chair of constitutional law, and is also an adjunct scholar at the Cato Institute
and the Georgetown Center for the Constitution.
The Constitution, there you go. Professor Blackman has authored 3 books, including An Introduction to Constitutional Law, which I have to say produced an excellent video series. Many of us in Conla 2, Professor Barnett, know him from.
Shorter hair, though.
Yeah. I mean, I didn't recognize. I was like, wait, the other guy?
Yeah. COVID was not good to me.
Yeah, exactly. Professor Blackman has written more than 5 dozen law review articles that have been cited nearly 1,000 times. He was selected by Forbes magazine for the 30 Under 30 in Law and Policy. Is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league, which I was surprised to find out. Professor Blackman's work was quoted during 2 presidential impeachment trials and testified before Congress and advises federal and state lawmakers. He often appears in television news programs like Fox and NBC, as a frequent guest at NPR, and published commentaries in leading national publications. Professor Blackman holds his JD from George Mason and a Bachelor of Science from Penn State. So thank you for joining us today, Professor Blackman.
Thank you so much.
Also joining us is Mr. Stuart M. Gerson. Mr. Gerson is an attorney at Epstein, Becker Green and has extensive experience in litigating cases involving the cybersecurity, healthcare information, trade secrets, and other confidential data, as well as civil and criminal fraud issues. He also defends various antitrust and securities matters for clients in the healthcare and financial sectors. Mr. Gerson was appointed acting Attorney General of the United States during the early Clinton administration after having served as President George H.W. Bush's appointee as Assistant Attorney General for the Civil Division of the DOJ, where he worked as the federal government's chief litigator in all major matters. In addition, Mr. Gerson has served as the Observer Delegate of the United States to the Council of Europe Ministers of Justice. He was a member of George H.W. Bush's administration National Healthcare Policy Working Group as head of its Medical Malpractice Firm Working Group, and as a spokesman on matters of civil justice reform. He has also served as an advisor in various capacities to several presidents during their campaigns and transitions into the White House. Mr. Gerson also writes a blog series about Supreme Court rulings and dynamics titled SCOTUS Today on LinkedIn. He's a graduate from Georgetown University Law Center, so welcome back. And has lectured here, as I found out.
In this classroom, in fact.
In this classroom. And is also a graduate from Penn State. Yeah, so without further ado, I will turn it over to Professor Blackman to tell us about his perspective on the constitutionality of the special counsel.
Thank you so much. Thank you. That's okay. Clap for him. It's a pleasure that my dear friend and colleague, Professor Barnett, is here. It's a joy of my life to write the book with him, and I'm so happy you're all learning from it. And one of the 100 cases that we picked that everyone should know is Morrison against Olson. This was a case decided in the late 1980s in one of Justice Scalia's first terms in the court. And this case considered the constitutionality of the independent counsel statute. Now, the court upheld that by vote 7-1. Justice Kennedy had not taking the case, he just joined the court. The majority opinion by Chief Justice Rehnquist explains that this statute is valid. Let me just walk through some of the parts of this statute. When there's allegations of some sort of misconduct within the government, the Attorney General has more or less an obligation to request the appointment of an independent counsel. And who appoints it? Not the President, not the AG, a special division, a panel of judges on the DC Circuit. This independent counsel then serves for as long as this person perhaps needs to serve to complete the task. If the independent counsel needs more authorization, they go to the courts to get it. The removal standard, though, is very hard. In theory, at least, the independent counsel can be removed, but there's also a judicial review. It has to be a very high standard of cause. This was meant to insulate them and provide independence. Chief Justice Rehnquist, again, no squish, wrote the majority opinion, finding that this practice was constitutional, and he relied in part on earlier special counsels going back to the Watergate investigation. I'll come to the Watergate in a few minutes. Justice Scalia wrote perhaps his most famous dissent, and he said, "This wolf comes as a wolf." That is a violation of separation of powers in two primary ways. First, to have the courts appointing what's effectively a prosecutor blurs the separation of powers. And second, by insulating this core prosecutorial power from presidential removal, it's basically an unchecked branch of government. Now, after Morrison, we had many investigations. If you were alive in the 1990s, which most of you probably were not, Ken Starr spent many years investigating Monica Lewinsky's dirty laundry, as it were. And there were lots of, frankly, embarrassing allegations that came out. Come 1999, the statute to be authorized. And both Republicans and Democrats said, okay, let's maybe let this one go away. And they did not reauthorize the independent counsel statute. It is defunct. It's no longer in effect. But that same year, the Reno Justice Department enacted a series of regulations, which created not an independent counsel, but something called a special counsel. The nomenclature doesn't matter, so let's go use the right terms. The special counsel is not appointed by judges. The special counsel is appointed by the Attorney General. And there are protections. That is, the special counsel can't be removed for any reason, but in theory at least, the AG can repeal the regulations, and that would remove the special counsel immediately. During the Bush administration, there were some special counsels going against Scooter Libby and other people involving in various scandals, but nothing of significance. The first big special counsel with new regs came with President Trump. He fired James Comey as the FBI director. And I was like, aha, you fired Comey because he's investigating Russia, right? You cannot have that. That's obstruction. So the Attorney General had recused, so we had acting Attorney General Rod Rosenstein appointed Robert Mueller to be the special counsel. And that investigation took several years. Ultimately, Trump was not indicted. He was not issued a subpoena. And there was a report released. If you read it, it's very long. Mueller more or less says, yeah, I would have indicted Trump, but I can't because he's sitting president. But whatever. Here's a report to just air out all these grievances. Okay. So the Mueller report sort of ended without much of a bang. There was an impeachment. Trump was acquitted. There was another impeachment. Trump was acquitted. And then January 6th occurred. Right? And in the wake of January 6th, a lot of people were indicted, but initially not Trump. And nearly 2 years into the presidency, after prodding by President Biden, Garland and I said, okay, fine, I'll appoint a special counsel. His name is Jack Smith. He was actually prosecuting war criminals in The Hague. He came over to prosecute Trump. I guess those are similar lines of work. The gravamen of the Smith indictment is twofold. There was one case in Florida. This is the Mar-a-Lago case, where it's alleged that Trump kept presidential records in his home in Mar-a-Lago after he left office, and he didn't return to the DOJ. Okay, that's case number one. Case number two is filed here in the lovely District of Columbia, involving Trump's actions leading up to and during January the 6th. Trump was not charged with insurrection. That's a debate I had last semester at the school. Instead, Trump was charged with obstruction of official proceedings. That is, he riled up these people to go to the Capitol and stop the vote count on J6, the joint session of Congress, and related things. There's an issue here of presidential immunity, which I am not going to talk about today. There's a decision upon that. Weird decision. That's separate. But another issue presented is, was Jack Smith properly appointed? Now, the title of this event was his appointment constitutional? And maybe if I had to tweak the flyer, I would just a bit. Whether this violates the Appointments Clause is a separate question, whether the statutory authority exists. Judge Cannon, who's in Florida, did not rule on the constitutional question. I nudged her to, but she didn't. That's fine. Instead, she ruled on the statutory question. And in fairness, I submitted an amicus brief to Judge Cannon, and she let me argue. This doesn't happen much. I got 30 minutes of argument time as an amicus. Cool. Right? That was actually a very fun experience. I enjoyed it quite a lot. And people say she's this awful judge. She's not very smart. She was on top of things. She yelled at me a few times. She got mad at me. I was a little bit out of bounds. She pushed back. I thought she was very fair. So a lot of these criticisms, I think, are out of bounds. Okay. Now, what did Judge Cannon actually rule on? She said the statutes that exist do not support Smith's appointment. Let me just sketch this out. Smith says, I am an inferior officer of the United States. Okay, what does it mean to be inferior? If you're a principal officer, we all know this, the president nominates you and the Senate votes on you, right, confirms you. No such appointment happened here. This was not Joe Biden, it wasn't the Senate. But the inferior officers are different. Their appointments can be vested by law, that is by statute, in the heads of department, which would be the Attorney General. So the question is, did Congress give A.G. Garland the statutory authority by law to appoint an officer known as a special counsel? That's the actual issue. It's not an Appointments Clause issue per se. It is their statutory authority. And Judge Cannon said no. That the statutes here at most allow the appointment perhaps of employees and people to investigate and assist U.S. attorneys, but Jack Smith has all of the powers of a U.S. attorney. So whatever powers a U.S. attorney has, he has, without the Senate confirmation. Okay, so I filed a brief on behalf of Professor Tillman and the Landmark Legal Foundation of this Mark Levin's group. We have a slightly different argument, which wasn't accepted, but it's in there. We argue that Smith actually isn't an officer at all. In Lucia, which you may have studied, the court said, to be an officer, you must have a continuous position. That is, when you finish, someone else steps into your shoes. There's continuity between holders. Jack Smith has no Jack Smith has no continuity. When his position finishes, the office dissolves, vaporizes, it disappears. He's not an officer at all, he's an employee. And as an employee, he cannot exercise the significant authority of the United States Attorney. So we made this argument, it's sort of lurking in the background. And if you actually look at Jack Smith's new briefs, he's basically going to our fallback. He's going to say, well, if I'm not an officer, I'm an employee. Just watch, he's going to make this pivot. We've vindicated like we've been in the past. But I want to talk now about the statutory authority. It is certainly true that throughout American history there are many special counsels. By the way, who knows what year DOJ was created? Anyone know the year?
Yes, I do.
Not you. No one else?
Is it under Grant?
1870. Bingo. Very good. So you did not even have a DOJ until 1870. So what you had was basically one United States District Attorney, what we call U.S. Attorney now, in each federal district. And obviously they can't do all the work by themselves. It's just not possible. So they would actually farm out contract work to lawyers, and they call them special counsels or special prosecutors, or different nomenclatures used. I have no problem with the government hiring outside counsel to assist a U.S. district attorney. That actually doesn't bother me, so long as an actual U.S. attorney is the responsible official. Now, I've actually done a lot of historical research on this, and I found some fascinating stuff. In the litigation, Jack Smith has cited sort of 6 high-profile scandals in American history where outside lawyers were nominated. And Smith said, aha, here, these outside counsels were the same thing as me. They're comparable to me. This proof. So let's go through them one at a time. During the Buchanan administration in 1858, there were some land disputes in California. The Attorney General hired Edwin Stanton. Ooh, terrific. Who knows what Edwin Stanton is? Why is he famous? Yeah.
He was Lincoln's war secretary, and Grant tried to nominate him to the court.
Johnson fired him, which led to the impeachment. Right? So Stanton, before he was a big deal, was actually a special counsel. People don't actually know this part. But he was a special counsel to assist the district attorney. The second one involves the prosecution of Jefferson Davis, which we've heard all about this direction. I am stuck in a time I can't get away from this prosecution. So at the time, the AG had retained 3 or 4 lawyers at various junctures to assist the U.S. attorney in Virginia. Smith says in his brief that these outside lawyers were in charge. No, they weren't. He just cited secondary sources. I cited the primary sources, which they were assisting them. If you actually even look at the opinion, he says assisting. So there's no problem with outside lawyers assisting. Going to the Grant administration in 1875, there was something called the whiskey ring scandal. Remember the whiskey ring scandal? There were all these corrupt excise taxes. It was actually a really big deal in the Midwest, St. Louis in particular. There was a U.S. attorney. They retained an outside lawyer to assist. And after their jobs were completed, their positions terminated. It's actually kind of funny when one of these lawyers found out. One of these lawyers was investigating President Grant's secretary, and when Grant found out they were investigating his secretary, he said, "Okay, fire him." So even though you had these independent counsels, when they got close to the White House, they were terminated almost immediately. So this is not a good precedent to stand upon. During the Garfield administration, he didn't live very long as president, but there was another scandal called the Starbout scandal. He appointed two of these, it wasn't him, the AG appointed two special assistants. They were helping, they were not working by themselves. Same during the Theodore Roosevelt administration, you had various outside lawyers appointed who were special assistants. My favorite is the Truman administration. This one's a great story. There was a scandal about the Internal Revenue Service. The AG appointed a lawyer to investigate corruption in the administration. So this lawyer said, okay.
Newbold Morris, one of the greats.
And you know what happened to him?
You'll tell me.
Oh, he didn't end well for him. So Newbold Morris said, I have an idea. I'm going to send all these executive branch officials questionnaires, asking about their finances. And I want to find out if they have a lot of income they don't used to have to prosecute investigation. The AG found out about this, and he fired him. He fired him, saying, "You are not sending that questionnaire." And this is classic, this audio, this. President Truman at a press conference. He knows. Truman has his press conference. He's walking through, he's like, "Here's my business, da-da-da-da-da. By the way, the Attorney General resigned." He just mentioned this in passing. And like the reporter went, "What happened?" And he's like, "Yes, the AG resigned." And the reporter asked Truman, "Did you know that the special counsel is being fired?" And Truman says, "I learned about it in the newspapers." So my point is, before Watergate, at most, these people were assisting U.S. attorneys. At most. This is not a lot. But everything changed with Watergate in more ways than one. So, have you studied U.S. versus Nixon in common law? We have a very good video on this that lays out the chronology of what happened. But long story short, initially, a special prosecutor was appointed. It was Archibald Cox. Okay? And Cox was assigned to investigate the break-in at the Watergate Hotel. And he started getting closer and closer to the White House and to Nixon. They started realizing something was going on. Then we have the famous Saturday Night Massacre. You learned about this? Right? This is just the stuff of legends. Where Nixon had not appointed Cox, so Nixon couldn't fire Cox. So Nixon orders AG, it was Richardson, right? Fire Cox. And he said, "I'm not going to do it." Why? He made a promise to the Senate to support the prosecution. So he wouldn't do it. He resigned. The deputy, it was Ruckelshaus, said, Nixon said, "Fire Cox." Ruckelshaus said, "I'm not going to do it." Now, by the way, they knew this was coming, because who was number 3 in the department?
Solicitor General.
Solicitor General Robert Bork. Yes, that Bork. It's like Forrest Gump, you're repeating figures over and over again. Bork had not made a promise to the Senate to support the support the prosecutor, so he fired Cox. Okay, and this fact is actually very important. All 3 of them agreed that Nixon was given a valid order to remove them, or remove Cox, but they had promised the Senate. And if you make a promise to the Senate and you don't want to make an order as a government official, you can resign. You can do that. But then Bork issues these regulations to protect another Watergate prosecutor. And this would be a person named Leon Jaworski, who would become the second Watergate prosecutor. But I want to just tell you what kind of protections Bork gave to Jaworski. These are frankly stunning. Ready for this? The only way Jaworski can be fired is if the president got a consensus from 8 members of Congress. What? You didn't know that, did you? That only if the minority leader, the ranking minority members of the judiciary, like basically 8 members of Congress had to consent to fire this person. Now, in a case called Boucher v. Sinar, I remember that from the 80s, right? You can't put the removal power in Congress. So the Bork regulations, I think, were unconstitutional at the get-go. They were kind of weird because there was acquiescence, the Senate agreed to it, the Nixon agreed to it, was under fire. But these regulations are, I think, very shaky ground. So whatever whatever the value of the Nixon press is, I think it needs to be limited to those facts because it was such an unusual regime, right? So this brings us to the present, right? For the 11th Circuit, there's briefing on whether the special counsel is unlawfully appointed. I put an amicus brief in about 2 weeks ago, I think he was. And also I preserved an issue. So this is probably why Randy hired me. I often push where I shouldn't push. At the very end of my oral argument, Judge Cannon says, "Thank you, Mr. Blackman. You have time." I said, "Judge, one more thing." Steve Jobs, just one more thing. And I said, "Judge, I don't know if I can do this, but I'm going to anyway. I'd like to preserve the issue of whether Morrison v. should be overruled. Amicus can do this. I'm preserving it." And the DOJ lawyer was like, "What the look on his face was like, what's going on?" And then he came up with a rebuttal and said, "Judge, did I hear Mr. Blackman correctly? Is he trying to overrule Morrison?" And the judge is like, "Yeah." So the issue has been preserved, and should this case go to the Supreme Court, I think maybe not 5 votes, maybe there are 5 votes. It depends if Trump's out of office or not. We might get a willingness to revisit Morrison. I think it's been scaled back by Edmund and later precedents. I think it's on light spark to steal the law. So maybe Justice Scalia's final victory will be like Lemon's gone, Roe's gone, Chevron's gone, Grutter and Gratz are gone. What else am I missing? Anyway, maybe Morrison will be gone next. Thank you all so much, and welcome Stuart's comments.
Thanks very much for having me. I come here with a lot of nostalgia. I'm one of the original members of the Federalist Society. I had a single-digit membership card. William Bradford Reynolds, then the Assistant Attorney General for Civil Rights and probably the President's closest actual advisor on legal matters, was a friend of mine and insisted that I join this fledgling organization and introduced me to Steve Calabrese, and the rest is a footnote to history. And speaking about history, I'm especially glad that Professor Barnett is here because he's an excellent historian besides being a good lawyer. And I'm going to talk about originalism in a sense with regard to the topic today. And it's also nice to be back at Georgetown. I didn't go to law school in this building, though I've taught in this room before. I was in the previous building, and it was in a constitutional law class of mine in the second year of my studies at Georgetown when I became a constitutional lawyer. My teacher was the legendary Father Joseph Sneed, S.J., one of the most brilliant men ever to teach anywhere at Georgetown. A troubled man, but a brilliant man. And he had a good sense of humor, and he called on me one day when I was less than well prepared. Mm-hmm. And I gave him a somewhat facetious answer, to which he said, "Mr. Gerson, if you're so smart, you'll teach this class." And I was made to come up to the lectern, and 3 sessions later, I was still there, working my way through the casebook. That's the most valuable period of time, by far, of any period of time I spent in 3 years of law school. I recommend getting into such a situation if you can. It's also something of an anomaly for me. I'm an actual jurisprudential conservative. I'm not what the MAGAs call a conservative, or these people who want to invade every aspect of your life. I'm one of those old-fashioned, limited government, strict interpretation, separation of powers type of persons. So it's something of an anomaly that I'm taking the pro side in the authority of the special counsel, constitutional authority, to do what he's doing. My own personal history, in fact, contains a number of examples where I believe that separation of powers concerns should have ruled with respect to the establishment and conduct of non-DOJ prosecutors. As an assistant U.S. attorney, I actually litigated the first case that had anything to do with Watergate that came before a judge. It had to do with checks passing around the country to finance the plumbers, and there was a case argued in the Superior Court of the District of Columbia, the state analogy to, or the District of Columbia analogy to a state court, and it reflected upon a statute called the Uniform Act to secure the attendance of out-of-state witnesses. In that case, Maurice Stans. And I worked closely with Earl Silbert and the original Watergate prosecution team. And so like they, I was somewhat chagrined since we were doing a very good job, and Silbert had just gotten an admission from one of the plumbers that ultimately proved to be the downfall of Richard Nixon long before Leon Jaworski succeeded Archibald Cox. I thought we were doing very well, and so we bridled at that. And in subsequent years, I advised two presidents to let the independent counsel statute expire. One of them listened to me, President George H.W. Bush. The other one, President Clinton, wasn't so astute, and it didn't work out so well for me. That said, we had the independent counsel statute brought back. The professor gave a very good recitation of the history. And at this point, here we are, that we're going to reach a point of disagreement. I, like he, read Morrison against Olson, lived with it in a number of cases. In fact, I'm a friend of both Morrison and Olson. That said, I was more than a little sympathetic to Justice Scalia's dissent. But against that background, notwithstanding the fact that Justice Scalia had a lot to say that was very worthwhile, one must recognize that the court's approval of the independent counsel construct in Morrison against Olson still stands, notwithstanding that it arguably was substantially weakened by Salem law and Arthrex. It still stands. And among the things that one finds in the majority opinion, the opinion for the court, in Morrison is Chief Justice Rehnquist's statement that the independent counsel didn't unduly trammel on the authority of a coordinate branch, and that an independent counsel is an inferior officer under the Appointments Clause of the Constitution, with limited jurisdiction and tenure and lacking policy-making or significant administrative authority. That's the independent counsel that no longer obtains. I'll talk in a second about how the special counsel is less empowered than was the independent counsel. I can talk about it now. I mean, the professor actually did much of my work for me. You're welcome. Just put it on the tab. But there's some big differences between the independent counsel that was upheld and what a special counsel is today. First, the special counsel is appointed either by the Attorney General or an acting Attorney General. I was one of those once, and appointed a lot of special counsel, as a matter of fact, to do a variety of things. The Justice Department retains outside counsel in a lot of things all the time, and I did that. But as was noted, the independent counsel was otherwise appointed in accordance with the approval and participation of a coordinate branch of government. Special counsels are much less independent because the Attorney General can appoint them and supervise them. And here's everyone touches on the assistance question, and I think definitively so, and I'll explain why. And remove them. A for-cause kind of termination is easy to establish where a special counsel is violating standing Justice Department policies. That's part of the reg. But again, as the professor helpfully noted, the whole function can be abolished because it exists by fiat of the Attorney General. It's a fiat that's very consistent with history. Before 1870, and certainly thereafter, the professor told you all about the post-1870 cases. We can talk a little bit about cases that started in 1790 as well. So we see that the independent counsel regime the constitutionality of it has never been overruled. Morrison against Olson, as has been correctly noted, still stands. The most important part of Morrison against Olson is the court's explicit holding that an independent counsel is an inferior officer. If an independent counsel is an inferior officer, certainly under the reasoning of the court, a special counsel is an inferior officer. Much greater discretion on the part of the Attorney General. No downside for a coordinate branch, doesn't weaken Congress at all to have it. Doesn't affect the judiciary, takes the judiciary out of the picture and keeps it where it belongs. So there we are. This conclusion, I suggest to you, is enhanced because the issue hasn't gone unnoticed. While the professor mentioned to Judge Cannon, whose record on appeal is not particularly good, that this issue was out there. In fact, it got out there in a way that has nothing to do, well, nothing at least immediately to do with Judge Cannon, and that's in the recent case of Trump against the United States. A case that's in many ways, and I think the suggestion was there, that both jurisprudential liberals and jurisprudential conservatives ought to agree that this is a really flawed decision. But one of the things that there is to know about it is that in a decision that runs for, God knows, the syllabus alone is 6 full pages that I found very hard to read as an old man with fading eyesight. Nowhere in the majority opinion in which the Chief Justice was joined by Justices Thomas, Alito, Gorsuch, and Kavanaugh, nor in the concurrence of Justice Barrett, and to say nothing of the 3 liberals, is there any question raised concerning the authority of Special Counsel Smith, either to appear before that court or to prosecute the case on remand. Only Justice Thomas raised the matter of the Special Counsel's authority to prosecute these alleged offenses that are unprotected by the official duties immunity, but no other justice offered any support for his position. One recognizes that the court has a duty to decide the issue that's in front of it, and this issue really wasn't. But this kind of issue has been picked up by the court in any number of recent cases involving the Appointments Clause. And Justice Thomas stepped right up to the plate. He's done it before. And if we're talking about the Consumer Financial Protection Board or other functions of other agencies, the court has had no trouble moving into that area, but it didn't. And I suggest that irrespective of the arguments that we're making here, if this issue ever were to be raised in a petition, it likely would fail. But even if it didn't, I can't imagine how, at least given what I know of the court and the justices, that you'd ever get to 5 to have the special counsel declared unconstitutional. Why do I say that? Well, you count the 3 liberals, put them in the fold already. Put the Chief Justice there too, and put Justice Kavanaugh, who operated as an independent counsel. He's never going to say that he operated illegally. There's 5 the other way. So that's how I count anyway. All that said, I want to talk just a little bit more about kind of an originalist argument. When the framers of the Constitution did their work, they really didn't give any basic thought to the prosecution of criminal cases by federal authorities. That was something they thought about treason, but that was something that they largely thought, and we know it, would be a function of the states. It's a traditional function of state law. However, in the first federal criminal law is called the Crimes Act. And it was promulgated in 1790, and it enumerated 23 different crimes, most of them common law crimes, but the federal jurisdiction had to do with them being committed in a place over which the federal government had control. So there was this idea out there already that there is a federal statute that sets forth criminal offenses. Well, who's supposed to be the prosecutor of that? Well, it's the Attorney General. Except in 1790, there wasn't any Justice Department. And so we have a long history until 1870, when in the post-Civil War era, the Justice Department was created, and you had assistant U.S. attorneys and people to do these jobs. It was the Attorney General. The Attorney General, originally, first Attorney General was Edmund Randolph. It was a part-time job. And so who prosecuted whatever criminal cases were being brought? Lawyers who were hired by the Department of Justice. There's a long history of the department going to outside lawyers, and the function was one that, as successfully was described by the professor, was one that was under the administration of the Attorney General. And throughout history, and I can cite there were a lot of cases, including the post 1870 cases that were cited earlier, where prosecution was in the hands of private individuals. And if assistance, if the key to all of this is this element of assistance, I respectfully suggest to you that it's entirely satisfied under the special counsel regimes. The Justice Department has what we used to, when I was an assistant U.S. attorney, may still be called specials. There were lots of them, hired for a whole bunch of reasons. And who did they assist? Not necessarily U.S. attorneys, because a lot of them worked at Main Justice. They assisted the Attorney General, who, after all, is the supervisory authority over United States attorneys. So I think the logic of what the professor was arguing is at least equally applicable to special counsel. And as I say, it doesn't look like the court is particularly excited about it. Justice Cannon has had her own problems with the Fifth Circuit, and so we shall see what happens next in the 5th and the 11th, where the former president has found less than great success in having his cases argued. So, I mean, to me, the short answer is a pragmatic one. In the best of all possible worlds, I don't think we ought not have a need for special counsel, but we have it, and I think that it satisfies constitutional norms. The court has already held that someone with far greater power is an inferior officer, and to me that decides the case. So I'll await your questions, arguments, rebuttal, whatever, but as Al Smith once experienced when he was out campaigning for president, some guy hollered at him and said, "Al, tell him everything you know. It'll only take a couple of minutes." And he said, "Well, I'll tell him everything we both know. It won't take any longer."
Very good. Thank you so much.
One of the things I love about FedSoc is we have these internecine debates. People on the same side of the spectrum can disagree, which I think is actually healthy and positive. Thank you so much for coming, sir. A few minor points for rebuttal. If you need to go to class, whatever, that's not a problem. The first, in the Trump versus United States case, the Appointments Clause issue was not presented. So I'm not surprised that the justice didn't rule on it. Justice Thomas basically said, if it were presented, here are my thoughts. He does that a lot. Justice Kavanaugh has actually called Morrison a mistake. He's criticized the decision. I don't think he'd have any problem. I think living through living through Whitewater perhaps has convinced him this might have been a mistake. Now, let's talk about another case, Buckley against Vallejo. Remember, did you say Buckley yet? Okay, I've done Buckley yet. This was a case that does a lot of things, that free speech and campaign finance. It's also an Appointments Clause case. And there's a section of Buckley that described this hierarchy. They said, okay, in our system we have these officers of the United States can be inferior principal, and we have below them employees, right? And there's a long line of cases on the back of the 1860s deciding who's an officer and who's an employee. And one of the essential required attributes of being an officer is you have to have continuity of office. That doesn't mean it goes on forever, right? It means, is there continuity from one holder to the next? And if you read Morrison, Rehnquist discusses, Continuity means from one hold to the next. What's interesting about the independent counsel is that there was continuity. In the statute, if for whatever reason the independent counsel resigned or died or was fired, there would be a replacement that steps in. The special division replaces them. That's continuity. The regulations of for Jack Smith have no continuity. It's a position that's personal to him. If he were to resign today or get fired today, his office dissolves. There's no continuity in place. He cannot be an officer. They're Lucia. He can be an officer, principal, or inferior. It doesn't matter. Realize Randy's sort of smirking. All my stuff is calling people not officers. It's a constant theme. But it comes up. I know what an officer is. He ain't an officer. And if he's not an officer, he can't exercise the significant authority of Buckley. Therefore, Morrison is also separate. I don't even need to overrule Morrison to win on this one. All we have to say is he's not an officer. And there are lots of cases saying if you're not an officer, you can't exercise the authority of a U.S. attorney, which is an officer. That's all. I'll stop here, and I welcome some questions from the students.
Well, I just.
Oh, we can rebuttal, sure.
Well, this will be a quick one. In Morrison against Olson, the Chief Justice, writing for 6 of his brethren and himself, noted that the independent counsel was an inferior officer. Says it right in the opinion. I'll leave it to you and any rational examination. If the independent counsel, with far greater powers, much more discretion, is an inferior officer, subject to dismissal, an assistant, if you will, like an assistant United States attorney, unconfirmed by the Senate. Then a special counsel, who's more easily removable, has less powers, comes with the authority of the Attorney General to continue to supervise his work, which can be disowned in whole or in part at any time. That person is an inferior officer as well. I just don't think it's a close question. You can argue that it shouldn't be the case, but I think it's pretty clear that it is.
Very good. Thank you. Questions from the students, please? Yes, go ahead.
You just argued that Jack Smith is not an officer. I was here last semester when you argued that the president is
Yeah,
not an
something
officer. What then do you think is the test for an officer? Who is an officer?
So my colleague in Ireland, Seth Barrett-Tillman, I've written a 10-part series, might be longer by the time we're done, on the different offices and officers of the Constitution. Okay, the Supreme Court has given 2 general approaches to defining what an officer is. Okay, one is the test that Stuart mentioned, authority. How much power are you exercising? What degree of supervision is there? And that helps define the line between principal and inferior. And I'm actually not quibbling with that. But there's a second line of cases that goes back even further. It goes back to the 1860s, a case called Germain and Hartwell and Offermont. It's a totally different line of cases that distinguishes between officers and employees. And there are different criteria to be an officer versus an employee. One of which is tenure, right? What's your tenure? Are you at will or do you have some sort of protection? Another condition is your position continuous? That is, do you have duration, right? The language uses both continuous and duration. They mean, I think, the same thing. And in Morrison, Rehnquist says continuity means from one holder to the next, does it continue? Now, Lucia, decided in 2018 by Justice Kagan, says continuity is a necessary factor of being an officer. Even the dissent said it's a prerequisite. So I'm reading the cases. If an officer must have continuity, Jack Smith does not have continuity. And again, continuity does not mean it lasts forever. I get it. He's been in office for 2 or 3 years. He's been there forever. Continuity means what happens after he's done. And this makes sense. Are you a contractor that you're appointed for one time, you do your job, the position dissolves? Or is this sort of a position that has duration from one to the next? So I don't think Smith is an officer. And look, don't believe me. Read Smith's latest brief in the 11th Circuit. He's sort of hinting now that, okay, maybe I'm an officer. I think we've gotten to him. I think he actually recognizes the position. He's like, fine, if I'm an employee, I can do this anyway. He's going to find it some Buckley, which is fine. But I think you're going to see a pivot, like almost an Obamacare saving construction. Oh, even if I'm not a tax, I'm actually a penalty, right? Even if I'm not an officer, I can be an employee. Just wait for it. And we're ready for it.
Well, we'll see. As I say, all I can say is that the court has held that someone with greater powers is an inferior officer, and that's the law. It makes sense. I don't get a sentiment that that's going to change. And there is continuity. The continuity is in the Attorney General, and that level of supervision and those abilities. So the the continuity is there, the supervisory nexus is there. As I say, I was an opponent of the independent counsel statute, and the things that were the basis of my opposition, I think, have been cured by the status quo. Further affiant saith none.
With great power comes great responsibility.
Well, Spider-Man is the key.
Yeah. I actually tried using that line, Judge Cannon. She comes like, "Thank you, Mr. Black." She did not want to hear Spider-Man, so she cut me off. I said, with great power, she's like, "Thank you, Mr. Black."
It's quoted a lot. I have a partner who insists the most important quotation is leave the gun, take the cannoli. But,
That's good. I use that one a lot. All right, what other questions do you have? Yes, sir.
So if he is an employee, then what is the calculus constitution in terms of the powers he's exercising?
Right, and this is where Buckley comes in, the other case I mentioned a few moments ago. Buckley said that only officers can exercise the significant authority of an officer. What's unique here is that Jack Smith was given the powers of a United States attorney. And everyone agrees the U.S. attorney is an officer. Now, some people say it's actually inferior. I don't even care about that. If you give an employee the power of an officer, that's not allowed. Imagine that Merrick Garland said, we're going to assign a summer intern at DOJ the powers of a U.S. attorney. You're only there for a month, but mild stuff. You're a U.S. attorney. Go indict someone, right? I think we say you probably can't do that. Now, Jack Smith is not, the stature of an intern, but effectively is. It's a position limited for a very short duration. There's no continuity. There's no holding from one to the next. So I think he can't exercise his authorities. Go ahead.
And just a quick follow-up, but it was mentioned a couple of times that, you had at the founding or even like later these private attorneys who were given essentially, even before the Justice Department, essentially prosecutorial authority. So how do you
even afterwards.
Yeah, right. But I'm even thinking even if there is no DOJ, then it was really then it's not even there is no DOJ. It's just these private individuals who have this.
Sure. And I've gone through all this history. They were never given the full powers of a U.S. attorney, what we call the U.S. district attorney. They always were subordinate or assisting someone else. The key, look, if Merrick Garland had issued an order saying, Jack Smith, you are effectively a special AUSA, and you will assist me in the investigation of these Trump cases, I think my argument's a lot weaker. But the regs say get all the power of a U.S. attorney. That's the key linchpin that my argument turns on.
And my response to that is in 1790, there were no assistant U.S. attorneys. And yet we have the Crimes Act, which allows, and indeed there were.
There were district attorneys, though.
But
And they assisted.
But the assistance was assistance to the Attorney General. When Edmund Randolph was riding the circuit in Virginia, doing what he was doing, he was assisted by lawyers. But what was he? He was the Attorney General, and I really do think that covers the case. If an assistant United States attorney is someone who can provide adequate supervision, certainly the boss of assistant United States attorneys can do it.
Yes.
So I think you kind of just touched on this a second ago, but so theoretically your argument sort of stands or falls on whether the President and the Attorney General acknowledges officially a sort of continuity with this special counsel office, and could he theoretically just issue through executive action, or if you somehow got congressional approval that, this is something that will last forever?
I actually do think if the AG modified the regulations, which of course he doesn't have the power to do, and created continuity of office duration, I think my argument gets weaker. I think those who do that would be tantamount that the prior actions taken by Smith will traverse, and that's a risk, right? There's no guarantee the de facto officer doctrine saves it. So to even sort of switch horses midstream, if you will, would I think be a significant concession. But maybe we'll see. Who knows? If Garland says, "Aha, Jay Blatt, you are now the principal deputy special counsel to take over," I'd have to make a different argument then.
A lot of people are making that argument. Steve Calabrese, in a recent article, makes that very argument that the problem goes away if you use as special counsel somebody who is confirmed.
Well, that's easy.
And there is one now. I mean, in the case of Hunter Biden,
yes,
you have just such a person.
Agreed. If Biden were to designate, or Garland says, the U.S. attorney for the Southern District of Florida, Mazel tov, your special counsel, my argument goes away.
Durham is another example.
Durham was as well, but not Ron Hur, who investigated Joe Biden, because he was out of office by the time that happened. Thank you for the question.
Is there any, let me rephrase it. Do you think that there's a deficiency in the Constitution for prosecuting a president or something that will create a conflict of interest for the president? And if not, what would the founders, what would the framers, what would their answer be?
Well, that has nothing to do with a special counsel, but it is something that's near and dear to my heart. I was counsel for the government in the case of United States against Daniel Brewster. Brewster was a sitting senator who took bribes from the Spiegel mail order company in order to replenish his pocket. He was on the Post Office and Civil Service Committee, and in the 1968 campaign, he stood in for Lyndon Johnson's reelection campaign. He stood in for Lyndon Johnson against George Wallace, piled up large debts and used these bribes to replenish. When he was charged with that, he got up to the Supreme Court and argued that he was protected by the speech or debate clause, an argument completely analogous to the executive authority argument that was made. And the court said, you got lots of protection, but only for official acts. And that's a lot like what we're dealing with Trump against the United States. Among the things that are not, full disclosure, I'm an amicus. I was an amicus in that case, supporting the government. But under the executive vesting clause, which is the thing at issue with regard to what former President Trump was attempting to tamper with, according to the argument, the president has no authority at all. It's the president of the Senate, that is the vice president, which is why Mike Pence was under the gun. There can't be, in my view, any immunity for something where there's no presidential power. There are lots of other things like that too, including shooting somebody on Fifth Avenue. There's a lot of these.
I agree with that one.
A lot of these nonsensical arguments that are being made out there. So, and the answer is, we're going to learn more as Judge Chutkan resolves the remand. But even the Supreme Court acknowledges that there is some range of activity as to which a president enjoys no protection. We'll find out how I can argue it all day as to what it would be. Dealing with matters of executive vesting is one of them, because I look at the Constitution and the president doesn't have that power. But we'll find out what Judge Chutkan thinks about it. But in many ways, I don't know if you agree or disagree with me, Trump against the United States is an overrated case. There's still a wide open question as the extent to which a president can be prosecuted. I don't think it's going to happen. I think time is going to run out.
If Trump loses, time will not run out.
Yeah, if Trump loses, I would predict we might have a result something like President Ford dealt with.
You think Biden would pardon Trump on the way out?
Biden, it might not be Biden. It might be Kamala Harris, but
she would do it.
But we will see about that.
Maybe they pardon both Hunter and Trump.
There'll be a more interesting issue if Trump wins, which is he'll pardon himself, and we'll find out.
Well, what about this? My thought is, could he say, "I pardon blanket amnesty anyone involved in J6," without naming in particular?
I don't know the answer to that. I mean, I'm pretty sure we know what the framers had in mind. That their focus was on individuals, and we know who some of those individuals were.
When Ford when there was the pardon amnesty for the draft dodgers, were they particularly named, or was it just a sweep?
I don't know the answer to that. It's an interesting question.
I think you have categorical pardons.
It might be.
Yeah, in the back.
I think I don't have the answer for this, but another analogy is Jefferson's pardoning of the people prosecuted.
Sedition Act.
Yeah,
and I don't think they were named in particular. I can't recall.
Or Johnson's pardons.
Yeah, well, I mentioned Johnson.
Yeah. I think we've had categorical pardons before, and the question is whether he's swept underneath that.
Yeah, I don't disagree with it. In any event, you're presaging some issues that we may have the less than pleasure to learn about.
Okay, right here.
Oh yeah, that was just going to be my question: is whether the blanket pardoning of the Confederate soldiers, which certainly had maybe named some specific officers, but certainly had a broad provision.
Yeah, and I mean, President Johnson on Christmas Day in 1868 issued a pardon of all the former Confederates, or not all of them, but a lot of them, including Jefferson Davis, was swept in underneath that.
Right.
So I don't know, would a pardon of everyone involved in J6, or would that include the big guy? I don't know.
It'd
Be wild.
I don't know that we'll have a chance to find out about it, and I don't know if the Republic is more secure if we do. So there you have it.
Good place to end the debate. Thank you, sir.
Thank you. Let me say another thing. I just want to echo the point. I mean, we're both what you would call conservatives in our jurisprudential views. And it's good to see, notwithstanding with the state of the Republican Party, a lot of the absolute stupidity that we hear and read about every day, that you can have legitimate, intellectually based, historically based arguments on these points. Because let me tell you that none of this has received wisdom from the divine.
Amen. Thank you all.
Thank you so much.
Please tell me.